I mean, there's various methods to allocate the DRG payments. And there's one method that is clearly violates the statute. And that's the method that the secretary chose, which is to designate 100% of the payments to the hospital's fixed costs. The secretary admits this on page 24 of his brief, that under his apples to oranges method, the entire DRG payment should be considered compensation for the hospital's fixed costs. And here, the secretary reallocated 99% of Lake Region's DRG payments to its fixed costs. And what that meant is for 99% of the patients that it had treated throughout the year, Lake Region got nothing for the costs it incurred for providing necessary drugs, medicine, medical supplies, food, laundry, and similar costs that the contractor deemed variable. The statutory scheme cannot be read to take away and pay nothing for hospitals' variable costs. So the secretary developed, there's all other methods to allocate the DRG payments, one of which is in the secretary's regulation from 2017 going forward, and similar to the Provider Reimbursement Review Board's method. That's a reasonable way to grapple with the statutory scheme and provide an allocation. Another reasonable method is the method set forth in the hospital's manual, as the secretary repeated in the Federal Register and in its notice to the public about what the method is.
That's what you call apples to apples, and they call total.
Correct.
I mean, that one seems pretty bad too. That one's going to compensate. Excuse me. That one's going to compensate for variable costs as well as fixed.
Well, Your Honor, and that I understand the district court, that gave the district court pause. Like, how can what this manual actually says, how can what the Federal Register actually says, which is the adjustment is the difference between the payments, the entire difference between the payments and the costs, and the hospital receives a lump sum difference, the district courts surmised, well, that must mean some inappropriate payment of variable costs. And the answer to that is the manual actually tells you how to, the manual has a method that reasonably addresses the variable cost component. And that is, it defines fixed costs. This is the secretary's definition in the manual. Also in the original regulation preamble, fixed costs are those over which management has no control. And in a hospital setting, many costs are neither perfectly fixed nor variable. They're semi-fixed. And semi-fixed costs are those for items and services that are essential to for the hospital to maintain operation, but also vary somewhat with volume. And then the manual goes through two and only two ways in which you adjust the total cost figure. And in an effort to eliminate costs that are within the hospital's control and outside the secretary's own definition of fixed. And the first is elimination of staffing costs that are more than the fixed staff, the core staff that are required. Those are netted out, and the manual tells contractors precisely what to do in that situation, which is to take them out of the cost report, rerun for a new total cost figure, which, quote, that is the basis for the payment adjustment. And then the second adjustment is a hospital is limited to its lower of last year's costs inflated or the current year's costs. And you might ask, why is that? Well, the manual explains the reason for this. The hospitals assumed to have budgeted in the year in which it had a decrease based on prior utilization and have had insufficient time in that year to make significant reductions in costs. In other words, the hospital's costs in the reduction year are presumed to be mostly fixed and semi-fixed. And with those two adjustments, the secretary's judgment in the manual was that reasonably gets at costs that are within the hospital's control, and thus, as the secretary defined it, variable costs. So in that method, 100% doesn't go to variable costs. Some portion goes to variable costs, but it at least is an effort to grapple with it. In contrast, the secretary's apples to orange method makes no effort to account for the fact that the DRG payments are supposed to pay variable costs. The second thing I wanted to bring up is that here, the secretary says the two methods are equally reasonable, 0 or 2 million. Well, actually, they're mutually incompatible. The same exact cost figures, fixed, variable, the same exact payments yield radically different outcomes. 2 million, and if 2 million is necessary to compensate and does not overcompensate Lake Region, then 0 necessarily undercompensates. And beyond Lake Region here, the point we were discussing a moment ago about taking all of the payments and provide for fixed costs, providing 0 for variable costs. The hospitals, many other hospitals, it was 99% Lake Region case, but in many other hospitals' case, it was 0, literally 0. Many of the amici hospitals and the hospital in the Unity Healthcare case. Another point that I want to just hopefully make clear, it's hopefully made clear by the materials the secretary published. The manual does not just set a cap. The manual tells you precisely how to set a method. And the secretary changed that. The secretary changed the method, and the apples to oranges method is a change from the regulation. It imposes a lower cap, not fixed, not total costs and DRG payments, fixed costs and DRG payments. So the secretary has clearly changed the regulatory text without notice and comment. And regardless of whether the secretary is correct or not in terms of the manual, did it set a clear policy and dictate how they're to be calculated? The secretary admits that it had no definition, no formula until 2017. And that means the secretary could not either establish, and no court analyzed establish, or change the method. And the secretary, it first established the apples to oranges method in a adjudication, not notice and comment rulemaking. So that violates notice and comment. I say I'm out of time.
Before you sit down, can you tell me, your client is Lake Region Healthcare?
Yes,
Yeah.
Your Honor.
What's is that related to Lakes Regional Healthcare?
It is not, Your Honor.
They're two separate corporations?
Yes, there's a lot of lakes in the upper Midwest. But yeah, they're in Fergus Fall, Minnesota, and it's not the same entity or related at all.
We'll give you a couple of minutes to reply.
Thank you.
Did you overvote?
Your Honor, may it please the court, Life Overwald on behalf of the Secretary of Health and Human Services. I'd like to start with the disaggregation question that my friend started with. The hospital in this case did not allocate the DRG payments that Lake Region received to its fixed costs. It just treated them the same way that the statutory scheme does, as undifferentiated payments that a participating hospital receives for providing inpatient care to Medicare patients. That's entirely consistent with the governing statutory scheme, as well as the regulation in place at the time of the fiscal year for which this volume decrease adjustment was made.
Your method for all these hospitals getting 0, your method treats the DRG payments as being 100% for fixed costs.
Wait, it doesn't
How
treat
can
them.
that be?
It doesn't allocate them to fixed costs or variable costs. It just treats them as the payment the hospital receives for providing inpatient care.
For fixed costs. Under a statute that requires disaggregation for fixed costs of the basic amount already received through the provider payment system and the unreimbursed amount.
Your Honor, the statute does not require disaggregation. Nothing in the statute talks about disaggregating the payments
The
a hospital
statute says you have to fully compensate the hospital for fixed costs.
for fixed costs. And it also provides that the payment the hospital receives is this DRG payment, which is not calculated on the basis of fixed costs or variable costs. It's calculated based on these historic average operating costs from the 1980s, which wasn't sort of calculated in the first instance on the basis of some portion is fixed, some portion is variable. And in the same way that this court addressed in Appalachian Regional,
The adjustment payment just reflects an arithmetic subtraction, right? You start with the hospital's fixed costs, and then you subtract out, you have to figure out unreimbursed fixed costs. And you do that through the DRG payment, right?
that is correct. I mean,
But it's in order to determine unreimbursed fixed costs. So you have to figure out how much of the DRG payment is attributable to fixed and how much is attributable to variable. And that's unavoidable. And your method just says we'll treat it as compensating for fixed.
Well, nothing about the statute requires this sort of disaggregation. And in particular, I mean, this scheme was adopted in the 80s to move away from this sort of dollar for dollar reimbursement scheme.
Statute requires calculation of unreimbursed fixed costs.
It requires such adjustment as may be necessary to fully compensate for fixed costs. It does not provide a basis for disaggregating the DRG payments
It's a
into a
little
fixed
more,
cost
but
component.
it's you have to figure out unreimbursed, right? Because there are two payments. There's the DRG payment on the front end,
But
and then there's the adjustment on
you
the
have to
back.
conclude whether an adjustment is necessary. That's what it says, as may be necessary to fully compensate for fixed costs. And if you're provided an undifferentiated payment, that again, like in Appalachian Regional, it's not broken down into particular services, particular cost categories. It's reasonable to treat it as compensation for fixed costs. You know, the statutory provision at issue, nothing, it doesn't mention variable costs anywhere. Fixed cost is only mentioned in this adjustment provision. And my friend, I mean,
The DRG scheme is supposed to compensate hospitals. A reasonably efficient hospital is supposed to get whatever they're supposed to get, right? It builds in what you would expect
it's a fixed
costs to treat a patient for a particular ailment, right? Comes in with a heart attack and you get whatever, $10,000 for treating the heart attack.
It's a fixed payment generally based on historic average operating costs and then with this sort of adjustment so
And
that
you think it's reasonable to view that payment as not compensating for any of the variable costs?
it's
that the
reasonable.
hospital incurs treating the guy who comes in with the heart attack?
It's reasonable for the agency not to sort of affect an allocation that the statute does not direct. And the one point I want to make, the plaintiff argues that the agency has changed its position in this regard, but no one is arguing that there was this previous practice of disaggregating the DRG payments into fixed and variable cost categories, and that changed. I mean, going back to the 1987 regulation, when it's talking about the cap, what you're subtracting of that is the entirety of the DRG payments. It wasn't until this series of review board decisions in 2014 where they started looking to the proxy of a hospital's own fixed cost ratio that any sort of effort was made to disaggregate the DRG payments in that way. And it's entirely reasonable when the agency is first presented with this sort of rough proxy, which I think everyone agrees, this is not reflective of the actual fixed and variable cost categories that might have gone into the historical calculation of the DRG payments in the 1980s. This is just hospitals' own fixed cost ratios, which might or might not be representative. It's reasonable for the agency not to sort of adopt that in the first instance, absent sort of a statutory or regulatory basis for doing so, and instead, again, treating the payments as the statute does, as this undifferentiated compensation to a participating hospital for providing inpatient care.
Am I correct if I understand this, that the higher in the old system, not the one that's in place now, that the higher the variable cost would be, the more likely the hospital would receive this compensatory payment, and the higher the payment would be?
I think, Judge Randolph, it would be the opposite. I believe that the higher a hospital's fixed costs are, the more likely those fixed costs might exceed its DRG payments. And to the extent it has not sort of,
No, I'm not talking about the system where you disaggregate. I'm talking about the system where you take a look at the DRG payments and you take a look at what the fixed costs were. If you have to disaggregate, and the higher the variable cost would be, then the fixed costs would not necessarily be taken or compensated for.
well, under the method the administrator employed here, the fixed costs, which are about 72%, and in this case, it does include all the hospital's semi-fixed costs as well. To the extent a hospital can show they're fixed or semi-fixed, then they're eligible for compensation. So the higher that number is, I think the more likely it is that that exceeds the DRG payments that a hospital has received.
That would mean that the lower the variable cost would be.
I think
as a percentage of the total payments.
I think that's right. If I'm understanding, I mean, the lower the variable costs as a percentage, the more likely you might receive an adjustment. I mean, it depends on what the DRG payments are, what the total number is. Whereas under this system, if you have to use the hospital's own fixed cost ratio as the proxy for sort of calculating it, the hospital that does have higher variable costs for whatever reason, that results in more of the DRG payments being treated as allocated to variable costs, even though that doesn't actually track how the DRG payment was calculated in the first instance.
Let me give you a numeric example. I hope this doesn't get too complicated, but I'll try to do it slowly. So let's say there's a hospital, perfectly efficient, they're well run, they're average, what CMS expects in every respect. And they have total costs of 100, fixed or 80, variable or 20. They're right on target. And so their DRG payment for the year is 100. Okay. Next year, they have a 20% volume decrease. Pretty significant, right? If not catastrophic, it's 4 times the trigger. Fixed costs are fixed, so they remain at 80. Variable, 20% decrease, they go down from 20 to 16. So their total costs are 96, if I have my math right, but only 80 are fixed. The DRG is going to go down. DRG is going to go down 20%, right? From 100 to 80. Under the secretary's method, their new DRG is 80. Their fixed costs are still 80. They're going to get zero compensation, notwithstanding a 20% decrease in volume. It just seems hard to square in a scheme that is designed to deal with this problem of these rural hospitals, and they're subject to these volume swings, and they have these high fixed costs, and that's the problem Congress is addressing.
I mean, I think the example generally tracks one that the amicus brief offered, and I think they presented an even third method for determining whether essentially the hospital had appropriately reduced its variable costs proportionate to the share. And that might be reasonable. And going forward from 2017, the secretary adopted another reasonable approach to remove any possibility.
Fixed.
Well, it's a version of finding a way to disaggregate these DRG payments that the statute does not provide, that the regulations before 2017 did not provide a basis to doing so. There are reasonable ways to further ensure that there's no possibility of any possibility of lack of full compensation, as the 2017 rule explains. But it's also reasonable for the administrator to look at a hospital that has fully received payments that fully total its fixed costs under a scheme in which the DRG payments are expressly not designed to mirror the dollar for dollar reimbursement of the old scheme. And a statutory direction to make sure that fixed costs are compensated obviously implies that there's no similar requirement for variable costs. When a hospital has received payments totaling its fixed costs, it is reasonable for the agency to conclude that the statutory directive is met in that situation.
When CMS prospectively sets the DRGs, do they consider variable costs?
Well, I mean, this gets to the sort of question of it's a
I mean, the
historical.
answer is yes.
It's a
We
historical-
both know the answer is yes. Right.
I don't think there's any way in which, at least I'm not aware that in setting these based on these historical, 1980s costs, certainly costs that a hospital might have would have treated as variable go into that calculation.
Setting the amount designed to compensate a well-run hospital for all the costs they have to incur to treat patients.
But
You don't think they're accounting for variable costs?
certainly there's no direction that the variable costs and the fixed costs both have to go into the DRG payment. Again, variable cost is not mentioned anywhere in this provision. And even then, if you have sort of some aspect of the payment historically included something that hospital would have treated as variable. I mean, variable costs vary across hospitals. They can vary for a particular hospital across time. That doesn't provide a basis for sort of disentangling this payment that this court has recognized is extremely difficult to disentangle given the move away from a dollar for dollar reimbursement scheme to this average payment that is expressly intended to have hospitals eat the excess when they don't provide when they provide an inpatient care and their costs exceed the average amount.
All right, thank you.
Thank you.
Mr. Collins, why don't you take 2 minutes?
Just Congress clearly included variable costs in the DRG payments. There's no question there. It's all costs, all operating costs. So that is baked into the payment structure. And counsel's mistaken when he says that this is completely different than the reasonable cost dollar for dollar. This is prospective payment. It's a new era. It's all efficiency. You get one payment. Your individual circumstances don't matter. The statute on its face says, including the reasonable costs of maintaining necessary core staff and services. Now, the question of, so that's inconsistent with the Secretary's interpretation here. The statute obviously doesn't direct how to apportion, and the Secretary has characterized it as a rough proxy, the method adopted in 2017 and what the board did. But the Secretary, of course, could have adopted a different proxy, but it needs to be something that addresses the reality that fixed costs, the variable costs are part of the DRG payment, and you simply can't fully compensate if you don't. Council mentioned the Appalachian case, and Appalachian was dealing with specifically cost-cutting measures. And Medicare shouldn't double pay the DRG payment plus something that was already paid by a third party. So that's the court construed there that was consistent with the PPS structure. We're not gonna give hospitals an out when they receive a payment for a discrete item. That's part of the payment that comes to us. Here, we're dealing with an exception intended to provide more money. So I don't think Appalachian is good, other than the fact that it has the language about the DRG payments and the nature of them. It's not a good, it's not a good source of, not good support for the Secretary. I mean, at the end of the day here, the question is, can the Secretary reasonably take money that it has already paid hospitals throughout the year for all of its discharges, money that was intended to pay for blood products, for medicine, for other costs the Secretary calls as reasonable and necessary to care, take that money and say, oh, here you go. Here it is again. That's your fixed cost payment. We submitted it isn't for both for substantive and procedural reasons. We asked that the court reverse the district court. Thank you.
Mr. Collins, I didn't want to take your time, but I do have a question about the impact of travel nurses. Are they considered, how are they considered as cost? They must be very cost. And how, and if you know,
That's an
how are they
excellent.
used by these small hospitals?
Yeah, it's particularly during the pandemic, a lot of hospitals had to hire nurses, traveling nurses to fill in gaps, to provide additional care. And, I'm not an accounting expert. I would think that those would be potentially deemed variable costs of a hospital because they can vary with utilization. If they're brought on to increase utilization, they could also fall in the category of necessary core staff if the hospital is lacking some of its core staff. But those are potentially the types of costs that the secretary's method simply wouldn't pay. And it's no coincidence that a lot of the volume adjustment payments that in the amici's cases and their records, in our case, are all during in the aftermath of the great financial meltdown when rural hospitals were struggling everywhere. And when the secretary is supposed to provide that protection, the secretary instead comes up with a new method that provides them nothing.
Rural hospital is defined as what, a hospital that doesn't have another hospital within 30 miles?
Yes, Your Honor, it's rough. I think it's 35 miles and
30 road miles.
yes, there's no other hospital essentially within the geographic area to service Medicare beneficiaries.
It's not necessarily a small hospital. It could be a very, very large hospital.
Well, they can vary in size, but typically they tend to be much smaller than hospitals that are located in urban areas under the prospective payment system. Their bed size is usually, in the 100 range versus the 500-600 range. So they tend to be much smaller. And they also, these hospitals are basically cornerstones of their communities. They're absolutely vital to the economic viability of remote rural areas as well.
Yeah. Okay. Thank you.
Thank you.
Thank you. Thank you, Your Honor.
Case number 23-1100 et al. Stern Produce Company, Inc. petitioner versus National Labor Relations Board. Mr. Scully for the petitioner, Mr. White for the respondent.
Mr. Scully.
Good morning, and may it please the court. The National Labor Relations Board has applied a presumption of guilt to a small family-owned produce company in Phoenix. And accordingly, their order is not supported by substantial evidence. To suggest that a union only files meritorious unfair labor practices is to deny a modern reality. It's true that the agency years ago found numerous violations committed mostly by a consultant Stern unfortunately hired in 2015. However, the agency has also dismissed numerous allegations levied against Stern in the same timeframe and since. Obviously, the company cannot claim its prior compliance should excuse its conduct in this case. Why does the agency get to conclude that no employer who has previously violated the law can ever act lawfully again? Administrative Law Judge Monte got it right. There's no evidence of discrimination here, unless you consider the egregiously insensitive and discriminatory outbursts of Mr. Ponce, his homophobic, racist, and Islamophobic rant towards other drivers. This agency seems to suggest that Stern made all of this up or embellished the circumstances, but we asked to what end? So we could sustain a written warning? Were the statements of Mr. Ponce not offensive enough? The board has departed from its precedent and by essentially removing causation from the initial right line test, and further by deconstructing Stern's legitimate reason for discipline in the case, requiring a quantum of proof that's more akin to beyond a reasonable doubt than a preponderance of the evidence. Add to this agency's completely unsubstantiated and unique claim that asking an employee to uncover a camera that has been in the employee's cab for years reasonably creates the impression of surveillance.
Let me ask you about that. We don't know from the record, do we, why Ruiz covered his camera?
We do not, Your Honor.
Okay, and why isn't it a reasonable inference that he covered it because he thought he was being watched?
Well, I think
I
that's,
mean, we've got
Yes.
cameras all over the world now, and we're probably, obviously when we don't know it. But that's my question is, why did he cover it? And I don't think the record indicates that he covered it every time he had a lunch break.
it does not, Your Honor, and there's no record evidence regarding that. The fact of the matter is that those cameras were installed years before. And in fact, the union filed an unfair labor practice charge over that, which was withdrawn, which usually means it's on pain of dismissal. So for years, he knew that he was being watched at all times. And moreover, in his testimony, Mr. Ruiz suggested that he could be observed even though he had covered up the camera. Because of the record itself, it's clear that no one knew that he was on break. The only thing that is indicated is that the text message sent from Mr. Barr was about uniform sizing initially. And in that regard, he also added the phrase, "Don't cover your camera," which is set forth in the driver's manual that Mr. Ruiz testified he knew about. He knew that the camera was to remain on at all times in his direct and cross-examination. I think, Your Honor, that this case demonstrates why appellate review of NLRB orders cannot be a rubber stamp. What happened in this case is that the agency just simply decided to find violations based on Stern's prior violations and alleged conduct in a settled case. Consider the reverse. If an agency dominated by employer interests overturned clear violations because it regarded the employer to be largely compliant with the act in prior cases, obviously that could not stand. This court has pointed out that while the substantial evidence test is not modified every time the administrative law judge and the board disagree, the ALJ's rejected factual findings are a factor for the court to consider. And I ask the court to pause on the quantum of factual findings by the administrative law judge that the board overturned. Here are some of them. That it was not out of the ordinary for the company to require the in-cab camera to remain uncovered. That a reasonable person could not conclude that the following message could give someone the impression of surveillance. Quote, "Got the uniform for sizing, bud, and you can't cover the camera it's against company rules," end quote. That Mr. Ruiz could not have known that Mr. Barr did not normally check the cameras, as that testimony only came out during the hearing. That there was no evidence that supported a conclusion that Mr. Ponce's written warning was in retaliation for union or protected activity. That Mr. Ponce's at least 3 clear violations of the policy were not comparable to other lesser violations of the anti-discrimination policy. That Stern does not follow a strict progressive discipline policy. That Mohammed Sheiko, the target of the comments of Mr. Ponce, was legitimately bothered by the comments. That Stern would have taken the disciplinary action regardless of Mr. Ponce's alleged union activity and activity with the board. These are all the pertinent factual findings of this case. In short, the agency's position amounts to innuendo based on Stern's prior conduct and allegations.
There's an oral reprimand. Does the supervisor or the company employee make a note of that in the individual's personnel file?
Yes, Your Honor, there's actually a form. And I think that one of the mistakes that the agency made in this case, Judge Randolph, is that it concluded that because the form indicated a verbal counseling, that it applied a strict disciplinary policy. But during the hearing, the agency had subpoenaed all the pertinent managers of this small company and had ample opportunity to establish that there was a progressive disciplinary system. There was not. There were cases that were elevated. And I think that what you're getting to, Judge Randolph, is the disparity that the agency tried to point to regarding the discipline of an employee by the name of Andre Woods. And the agency tried to say that Andre Woods had been given a prior discipline. He had not been given a prior discipline, and pointed to 2 violations of the anti-discrimination policy resulting in a written warning. In Mr. Ponce's case, there were arguably 3. The comments that stereotyped gay people, comments that assumed Mr. Chaco was of Arab descent or Muslim faith, and then also, of course, suggesting that Muslims want to kill gay people. So
I'm looking at the anti-harassment policy of the company,
yes,
which says discipline may include, but it's not limited to, reprimand, suspension, demotion, transfer, and discharge.
Mhm.
So Ponce's discipline was which one of those? Is it a reprimand?
yes, it was a written warning.
A
Your Honor.
written, yeah, so why does it matter whether it's written or oral if that's going into the individual's file anyway, if it's oral?
Well, I think that that's the point, Your Honor, that there was this unusual deconstruction of this small company's disciplinary policies. A written warning, again, is a lower form of discipline. I would suggest very modest under the circumstances of this case, to essentially, in other circumstances, an individual would likely be terminated for saying these things in the workplace.
Yeah, okay.
All right.
I did try to reserve 2 minutes. I just would like to sum up on the law, if I may. There's no.
I have
Yes.
another question.
Yes, sir.
About the other, the camera surveillance thing. Is it in the record that the company supervisor can communicate in sort of a Zoom-like fashion by looking at a person and talking to them on the telephone?
There's no audio for the camera, Judge Randolph, but when the supervisor pulls up a driver, a live feed of that driver's front-facing and cab-facing camera comes up, and that is in the record, and also was the subject of this
Yeah, well,
prior.
the reason I'm asking is because the message that was sent dealt with his uniform was ready or something like that.
Yes, sir.
And I guess you could inform him of that simply by the telephone itself, right?
Indeed. It appears that Mr. Barr texted Mr. Ruiz about the uniform sizing once he had determined that Mr. Ruiz was in a stopped status so that he could receive the text message, but the record does not provide that detail.
Okay.
But isn't it also true that this Barr, because that's what I was wondering, if when he texts drivers, which he testified to that he did regularly,
Mhm.
he checked first to see on the camera to see if they were stopped, and so forth. And doesn't the record reflect that he'd never done that before?
The record just reflects that he didn't recall sending the particular text in this case, Your Honor. It's somewhat limited on the details. He said that he had circumstances in which he checked the camera involving short stops and things of that nature.
Okay.
Thank you.
Why?
Good morning. May it please the court. Eric Weitz on behalf of the National Labor Relations Board. This case involves 2 narrow unfair labor practices based on fact-bound inquiries by the board, which are subject to the familiar substantial evidence standard of review, which, as this court has recognized in cases cited in our brief, is even more opposite the normal in these specific factual contexts where the board is evaluating the impact of an employer communication on an employee and evaluating potential discrimination. Turning first to the impression of surveillance violation involving Mr. Ruiz, the very first point I was going to begin with was the question you asked Judge Henderson about what the record shows in this case. Many of the employer's claims against the board's findings are based on factual assertions that simply have no support in the record. So as to the question of Mr. Barr's practice, I think Mr. Barr's testimony is very persuasive in this case as to the board's findings. Number one, as Your Honor noted, he testified at Joint Appendix 274 that he regularly texted and called employees during the day, given that they were out in their trucks and he needed to communicate with them. At the same time, he testified at Joint Appendix 270, Joint Appendix 275, that he simply did not access these cameras normally. He very clearly testified that these cameras were a safety device. The footage that they recorded were a safety device, which was meant to be used in case of an accident. So you would have coverage for liability for the driver and for the company, and you could show that an employee was not on their phone, et cetera. So his testimony.
What was the one about if he's stopped for 2 hours? Because as I understand it, this camera is computerized and I mean, nobody's actually looking at the camera, but the camera tells somebody that a driver has stopped for 2 hours or more. What's the purpose of that?
Well,
Frolic of his own or something, or what?
I mean, I guess he has the ability to access the cameras, and he testified how the system works is it's a camera mounted on the center of the windshield, which shows the entire cab. It's on 24/7, even when the truck is off, because it also serves as an anti-theft device. It's always running and recording. And this company, Samsara, has fleet software that you need to enter a user ID and password and log in and deliberately go in and pull up an individual driver. And if you do that, you can see the camera. And so he did
That's
test.
not what I'm asking.
Well,
I'm asking what purpose the the company policy of checking the camera or the camera alerting them when somebody has stopped for 2 hours or more.
yeah, I don't know if that was a formal policy. Mr. Barr testified that that was his practice in response to a question of what were these scenarios when you would ever look at someone's camera.
All right, did he say why he followed that particular policy?
Yes, I believe his testimony was, if something is abnormal, like a driver is in an area they're not supposed to be or has been stopped for a long time, he can check on them. There's no claim that that was a situation here. Mr. Ruiz was just stopped for his regular lunch break. And I'd also note that I think tellingly, Mr. Barr denied having ever sent this text, and the employer did not examine him and elicit testimony about the circumstances of this text. So the claim that on this circumstance, the reason that he was checking the camera was to make sure Mr. Ruiz was stopped in order to text him, that simply has no basis in the record and is actually directly contrary to his testimony about what his normal practice was. We don't actually have anything in the record explaining why Mr. Barr accessed the camera at all, which was a key component of the board's finding that this was highly unusual and would have been perceived as such by Mr. Ruiz or a reasonable employee in his circumstance, because there's no evidence of the employer having ever indicated to an employee that just while they were going about their regular job duties, they were being watched. Nor is there any.
Why did Ruiz cover the camera if he didn't think he was being watched?
Well, he testified that he was on his lunch break. The understanding was that these cameras are for safety purposes. That's at Joint Appendix 456, where he's affirming that he had an understanding of why these cameras were in the truck, which is that while you're driving and moving, it's a safety device. So he testified that he did cover it for privacy, but I don't think that supports the employer's further assertion that that means he thought he was being watched all the time and this was totally normal. For example, I'm sure many of us in the courtroom have cameras on our personal laptops and may feel some type of I think many people cover their camera out of some ambient concern about privacy. That doesn't mean they actually believe they're being watched at all times for no reason. This was the only instance in the record of an employee having been sent that message or told that that was the situation. And also, I would note that Mr. Ruiz clearly testified, and there's no evidence to the contrary, that he had never been instructed that he couldn't cover his camera during his lunch break.
That brings up footnote 7 in the board order, which I think is an absurd position. The board says, but the manual says when it can be turned off or disconnected. And you have to be specifically authorized for that. Then it says, but the manual does not address employees covering their cameras during break periods. And why doesn't the greater subsume? I mean, it doesn't say you can't turn it backwards or you can't turn it upside down either. I mean, if you can only disconnect or turn it off with authorization, that has to include, and you can't cover it either.
Well, Your Honor, I think it's less absurd, once you go through Mr. Barr's testimony. I'd point the court to Joint Appendix 251 to 266, where he explains the purpose of these cameras and how they work. They're on and connected to the truck's CPU 24/7. And so, as I mentioned earlier, even when the truck is parked and no one's in it, the cameras are running. They're meant to be on as an anti-theft device. So they're just always on and not disconnected.
Well, they can be, though. They can be just obviously if.
Correct.
Yeah.
And so I think the policy, and I think it's a reasonable reading of the policy, is that it's saying don't unplug this camera and disconnect it. That's what is specifically being prohibited. But it doesn't say we need to be seeing you at all times so we can randomly check your camera and check up on you. As I noted earlier at Joint Appendix 456, Mr. Ruiz, consistent with Mr. Barr, explained that everyone understood the purpose of these cameras were for liability in case of accident, for traffic safety. So there's no reason that an employee would have believed that part of the purpose of having the camera was so that while he's parked for lunch, his employer can check in on him. I'd also note in response to your question, Judge Randolph, there was specific testimony that this is not a Zoom type device where you can communicate back and forth. It's a soundless camera, and the actual communication occurred through the employee's cell phones, through texting or calling.
What evidence did the board have to indicate that the cameras were used for surveillance of union activities?
Well, the board didn't find an actual surveillance finding, Your Honor. They found an impression of surveillance. So there was no specific finding that actual union activity.
What basis did Ruiz have then for assuming or having the impression that he was being watched for engaging in union activities?
I think the board considered the totality of the circumstances. And so number
Well,
one.
I hope they do. Yeah. I mean.
Well, that is the board's.
That's a totally empty phrase. I mean,
Well,
who knows of a case that didn't consider the totality of the circumstances?
that's fair enough, Your Honor. I only pointed out that there's not a specific, the board considered the full context here. And so number one, you had the fact that Mr. Ruiz had been a longtime union supporter. He'd been a previous target of unfair labor practices, and he had just returned to work less than 3 weeks before this incident as a result of a settlement alleging that he had been unlawfully failed to be recalled from a layoff because he was a union supporter.
So if you're a union supporter, you can cover the cameras? Is that the idea?
No,
Because otherwise you might be thinking, oh my goodness, I'm being watched.
well, that's the first circumstance, but I think the second circumstance, and which is consistent with board law in this area as well as this court's law, is that when an employer does something out of the ordinary, that can convey an impression to a reasonable employee that they are being targeted in connection with their protected activities. So if the employer had regularly done this and regularly told employees that you cannot cover your camera or sent them messages indicating that they were being watched on their breaks, that would likely not be an unfair labor practice. But as I was discussing earlier, what's significant about this case is that
It was a manual that said you have to keep the cameras on at all times?
well, that's where the board had a different interpretation of that manual. I think it's reasonable to infer that what the manual is saying is you cannot disconnect this device. But no, there's no evidence that employees had received a general instruction, certainly not Mr. Ruiz. He specifically testified to the contrary, that he could not cover his camera while he was stopped and not moving in his vehicle, which is contrary to the understood purpose of these cameras, which is a traffic safety and liability device while the vehicle is moving and you might have a traffic accident.
So this camera only showed what was going on within the cab itself?
Well, there's a forward-facing camera that watches the road and an inward-facing camera, which the testimony is, so for example, if you're in a traffic accident, you want to have a recording of the driver to show that the driver was not on his phone, that no one can make a claim against the driver or the company, et cetera, so that you're protected. And Mr. Barr was very clear that that's the purpose of the camera and the abnormal situations when he actually checks the camera. If there's an accident or a harsh braking event, or Your Honor's question, other unusual situations like a driver being stopped somewhere for a very long period of time. He did not check them just as a normal course of his job duties or explain why he did in this situation.
Let me ask you this. I thought you said that, I want to get your answer clear to Judge Randolph. The driver safety manual requires, quote, all vehicle safety systems, telematics, and dash cams must remain on at all times unless specifically authorized to turn them off or disconnect. Now, did you say that Ruiz had no knowledge of this thing that's in the manual?
No, Your Honor, I was just making the point that I had been making earlier that the board's reading of that language is that the employees cannot turn this device off or disconnect it, which is different than leaving it unobscured while they're parked in their truck.
Right.
The device here was still running.
And we've been through that.
Correct.
If you're told and you know, don't turn this thing off, that included in that is don't cover it, don't play with it, don't break it. I mean, I don't know how specific they have to be. I want to ask you about the board order on J718, left column, the last full paragraph on the left column. The general counsel alleged that under these circumstances, Barr's July 13th interaction with Ruiz unlawfully created the impression that Ruiz, and then it says, and any of his potential union activity was under surveillance. Now, if he hadn't been on his lunch break, he would have had no business in being involved in union activity. I mean, he's on an 8-hour work shift, but for the word potential, he isn't supposed to be engaged in union activity while he's driving this truck.
Yes, Your Honor. And my question actually, I think, addresses both components of what you just said, both the fact that you could read the policy as saying employees can't cover their camera, and you could say that employees, while they're on working time, can be observed. That's true, but the board's finding here was actually broader than a finding that when Mr. Barr accessed the camera, he might have accidentally seen union activity. What the board found here was an 8A1 impression of surveillance, which is that the mere message to an employee that they're being singled out and watched has a reasonable tendency to coerce employees, even if he was not engaged in union activity at this time, or even if he had never engaged in union activity in the past in his truck.
What union activity could possibly be picked up by this camera? He's off in the truck. He's either driving or he's having lunch by himself. This is surveillance targeted perfectly not to pick up protected activity.
Well, I don't think the record shows that, Your Honor. This is the driver's primary work site throughout the day. So as we noted,
the truck. So
right.
People, coworkers are coming into the truck to sit with him to organize during his lunch break?
Well, Your Honor, as we note in our brief, they could be having discussions. They could be signing.
The camera wouldn't pick up the audio.
Well, it wouldn't pick up the audio, but I would submit that it's still, even if it doesn't have audio, the fact that your employer is watching you have a conversation is still highly coercive.
The fact that your employer has a camera pursuant to a generally applicable, previously published policy with all sorts of perfectly legitimate business justifications.
Well, again, as I was noting,
completely different from the case where, someone 3 levels up the chain of command all of a sudden is sitting in the passenger seat for a ride along.
Sure, Your Honor, but what that case was going to, which is I think similar to this case, which is that you can have coercion even if there's not actual surveillance of union activities. The mere message to an employee that they're being singled out and monitored more closely than normal is coercive under existing law.
Your theory on the first charge is not discrimination based on union activities. It's that the employer is surveilling union activities. And I just don't see what activities are.
Respectfully, Your Honor, that's not the unfair labor practice that the board found. There's a delineation under board law between an actual finding of union surveillance and an impression of surveillance.
Creating an impression of surveillance of protected activity.
Correct. Creating an
And that's a
impression.
hard inference if the camera is targeted to times and places where it's very unlikely that there will be protected activity.
Well, Your Honor, I would again push back against the factual assertion that it's very unlikely here, but I think the cases support the board's finding that even if he had not in the past engaged in union activity or even planned to in the cab of his truck, it's still coercive if your employer, which it has never done to any other driver, is indicating that it is watching you during the day. So for example, this court in Parsippany Hotel affirmed a similar finding where guards began following employees around throughout the workday and essentially intimidating them. In McArden, this court affirmed an unfair labor practice where employees were told that while they're going about the facility, they might be recorded, when in fact that wasn't even true. And that was not tied to any specific instance of union activity. What the court affirmed there correctly was that that is coercive to employees because you are singling them out in a way that you have not done to any other employee. So again, even if assuming there was a rule against covering your camera, there's still no explanation as to why Mr. Ruiz was singled out. And I think
Does the board have acknowledge the de minimis doctrine? Where, you know, one would say that this is so trivial that we're not going to bother with it.
I mean, the board does have a merit dismissal procedure, Your Honor. I would think this is a more straightforward unfair labor practice, but I think the flip side of that is that the remedy here for the employer is also comparatively mild. There's just a notice posting telling employees that it won't create an unlawful impression of surveillance.
It won't create impressions anymore.
Well, it specifically.
That's what the order says.
Yes, specifically that it will not violate federal law by creating an unlawful impression of surveillance.
It says, unless I've misremembered it, I think it says, cease and desist from creating the impression that it's engaging in surveillance.
Well, that's the board's order, and then there's a
Right.
concurrent notice posting that will actually be posted in the facility, but yes. So there is,
If you took the cameras out of the cab, then I guess you wouldn't be able to create that impression anymore.
well, no, you could, the board's order does not in any way prohibit the employer from using these cameras as it sees fit. If the employer were to promulgate a generally applicable rule that it had never done prior to this.
How about a rule
message.
that says don't disconnect or turn off the camera? That's a pretty general rule, isn't it?
Certainly, Your Honor, but again, there's two components to this case. Even if there's a generally applicable rule, if we assume that's the case, that does not explain why Mr. Barr accessed Mr. Ruiz's camera here. He testified that he did not normally access employees' cameras. And so why was Mr. Ruiz singled out, or why would he reasonably believe he was singled out? And that's the board's finding here, which I would submit is well supported by substantial evidence given the deferential standard of review. And I see that I'm obviously well over my time. If the court has any questions about
I have
the,
one last question. Has this election been held yet?
well, there was an election in the time frame of CERN Produce 1. There has not been
I'm not asking about that.
well, there has not been a subsequent petition. But I would note that the organizing campaign is active, contrary to the employer's claims. And if there's no questions about Mr. Ponce's unfair labor practice.
Thank you.
Thank you.
Should take 2 minutes.
Thank you, Your Honor. I'll be very brief. I just wanted to address what what counsel for the board spoke of in his argument, the testimony of Mr. Barr is all post hoc. The standard is, what is the impression that the employee has, a reasonable employee at the time? And the only evidence in the record is the text message that was sent. And so what the board should have looked at is, does that, in light of the prior dismissed unfair labor practice charge over the installation of these cameras, and in light of Mr. Ruiz's acknowledgement at Joint Appendix, I think 456, where he said, yes, I read and understood the driver's manual. Does that text create in a reasonable employee the impression of surveillance when they know all these things? And we simply contend that it cannot in these circumstances. And we ask that the petition be granted and the cross petition be denied.
Thank you.
Thank you.
Case number 23-5049. Silver and Monte Silver Limited and Israeli Corporation appellants versus United States of America. Mr. Zell for the appellants, Mr. Klimas for the
Mr. Zell, good morning.
Good morning, Your Honors, and may it please the court. My name is Mark Zell. I'm here for the appellants Monte Silver LLC Limited. Mr. Silverwood was intending to be here today, but because of the war in our country of Israel, that he was unable to join us, and he sends his regrets. Your Honors, imagine that you are a party to a simple tax court dispute challenging a tax assessment that does not involve any detailed consideration of the tax returns in the case. And suddenly, based on the district court's ruling in this particular case, the government comes back and publishes through a submission to the court through the electronic filing system and the Pacer platform, your private tax returns, your tax return information, your most confidential data throughout the entire world. Now, that is the question as we see it, as before the court today. Whether under 26 USC 6103, and specifically under what's called the Taxpayer Party Rule of 6103H4A, the IRS can carte blanche unilaterally publish on the internet all of your tax returns, gigabytes of irrelevant, highly confidential, and potentially damaging tax information without advance notice or any attempt to either confer or to stipulate or obtain a protective order or a sealing order, or otherwise to exercise reasonable care before it goes and publishes this material throughout the world on the internet. We say the answer to that question is no. The plain language of the statute and the intricate structure of 6103 coupled with the civil damages statute, 26 USC 7431. The legislative history of these statutes, both from the Tax Reform Act of 76 and subsequent amendments, the official publication of the IRS's own chief counsel, and simple common sense all dictate or indicate that a taxpayer's reasonable expectation of privacy, which is the core issue that prompted Congress in the first place to enact the legislation that is now codified at 6103 and 7431, is violated when the IRS makes a wholesale indiscriminate disclosure of this information to the entire planet. This is a case of first impression, Your Honors, in this court and perhaps in the entire country. The district court, in an unprecedented and extremely broad interpretation of 6103, but simply flips that statute on its face. And instead of protecting the taxpayers, the ruling that if left stand will open the door to the very sort of abuse that Congress intended to curtail when it enacted 6103 under the Tax Reform Act of 1976. With that, Your Honors, if you have any questions, I'll be glad to answer them. Otherwise, I'll reserve the rest of my time following the government's arguments on rebuttal.
I'd like to ask you about disclosure and privacy law reference guide, this publication 4639.
Yes, Your Honor.
And how you read the last sentence on the introduction called "to the reader." And the last sentence says, this guide was prepared for reference purposes only. It may not be used or cited as authority for setting or sustaining a legal position. And reviewing your submissions, you have relied on.
We have indeed, Your Honor, and we think it's
So how do you read that?
well, I read it the same way that the Supreme Court read the IRS's internal manuals in the Bittner case last term. And that is, it's not binding, it's not legally binding on the court.
The Bittner policy or guidance didn't have this language in it.
Well, I don't recall that from the court's decision.
Well, we looked at the case.
You looked at it,
Didn't
okay.
have the language.
Okay. Well, in any case, I think this expresses the IRS's position on this. I think it's instructive. It is not binding. However, even irrespective, our cases does not rise or fall on the language of 4639, although I think that's probably the most.
You've used it and cited it as authority. And so I'm asking how you read this last sentence that says it may not be used.
Well, that the IRS has used this. This is probably the single most authoritative assessment and by the IRS of the rules in this area. There is nothing else.
I agree with you, and
I believe
what the purpose of guidance is when it says it cannot be relied on.
I think it's self-serving. It's attempting to limit the effect exactly as Your Honor has pointed out of this document, but I don't think they can do that because they published this document. It's available not only to IRS counsel and IRS employees, but the entire world. And we relied on it when we prepared this case. We relied on that publication to understand exactly what the parameters are of the government's obligation of disclosure.
I get all that, and you were at the same time told you couldn't do it. So,
well, I don't think the IRS is not going to be the arbiter of whether, when it puts a document like this into the public domain and explains in detailed fashion how the disclosure provisions of Section 6103 are to operate and the policies behind that and the history behind that. It's extremely informative, and it's something that the public relied upon, Your Honors, when we undertook to enter this case. We did not expect that the government would take our private tax returns with all of this information without even talking to us and just publish it on the internet willy-nilly without any kind of limitation. This document, as important as it is not the ultimate authority on the issue. But what does operate, when you look at the plain language of the statute, this is a statute that creates a presumption of confidentiality. Yes, Your
I
Honor.
want you to answer my question. I asked you a very
Yes, you did.
targeted question. Is it your position that you do not feel bound by that?
We are not bound by that disclaimer. Absolutely not. So with that, I will, unless there are any more questions, Your Honors, I will reserve the rest of my time for after the government argument. Thank you.
To get this over with, what is the IRS's position on what that sentence means?
Yes, Your Honor. May it please the court, Jeff Klimas for the United States. This is a document that is prepared that gives high-level guidance that is supposed to be, for reference purposes, that is not supposed to be intended to be legally binding on IRS employees. It's supposed to give a broad overview and paint in broad strokes, but ultimately, the law is what the statute says and what the binding regulations say, not what is being painted in broad strokes. And typically, these type of guidance documents, whether it's the Internal Revenue Manual or the guide here, they're painted in such a way that they are trying to make sure that the law is not violated without necessarily expanding to the full extent of what the law actually authorizes. So for example, here where it talks about bankruptcy law disclosures, it's talking about what should be done in the context of a bankruptcy proceeding. It's not saying here is the outer limit of the government's authority under Section H4 in the context of a bankruptcy proceeding. It's using this precatory directive language should rather than using language like must or shall. It's conveying an intent that this is not supposed to be binding, but is counseling in terms of what is a best practice to make sure that we are not going to go anywhere near the line of violating Section 6103. That's what that guidance is intended to do.
How authoritative is it? I haven't seen something like this before. I'm just trying to find out, this is something that the IRS usually puts in its guidance or what?
I think that you're right. There are certain guidance documents that the IRS has not included disclaimer. So for example, I think the Internal Revenue Manual typically does not have that kind of disclaimer. I think it's a further weakening of the ability of someone to rely on this as something that's authoritative. That, this court has said, obviously the Internal Revenue Manual does not have the force and effect of law. This is a step removed even from that. And it really isn't in many of the instances in which Brother Counsel relies on it, isn't even trying to really interpret the statute. It's trying to give high-level guidance about what might be a proceeding pertaining to tax administration or how to approach a bankruptcy case. There are things in this guide, for example, when it says, well, a FOIA case involving a request for taxpayer return information is a proceeding pertaining to tax administration. And then we look at what the case law actually says. If we look at the Safeway or Crow or Greenberger case that plaintiffs cite in their opening brief, the case law says the opposite. So you have to be very cautious when you're looking at a guide like this that is painting in broad strokes. Ultimately, what we should be doing is looking at the statute and the binding regulations and not relying on this other guidance. We would submit that the district court in this case correctly held that plaintiffs' two prior suits, Silver 1 and Silver 2, were proceedings pertaining to tax administration because, as the district court said in Silver 1, all you have to do is really look at the relief that's requested, where plaintiffs were seeking to enjoin the enforcement against not only themselves, but all small businesses, the enforcement of regulations and even statutes that govern the calculation, reporting, and payment of taxes. That is quintessentially something that falls within the definition of tax administration as it's defined in the Internal Revenue Code. The administration, management, conduct, direction, and supervision of the execution and application of the internal revenue laws, including specifically the assessment, collection, and enforcement functions, which would be materially impacted if plaintiffs were to have prevailed in those lawsuits. It would have caused IRS revenue agents who are trying to implement their assessment and collection functions to stop what they were doing, put aside the regulations that they've been relying on, and do something else that falls directly within the purview of this broad definition of tax administration. This court in Gardner said that it is a fairly broad definition, and that is consistent with other courts of appeal as well. And in fact, that language is broadened by the preceding phrase pertaining to. The other arguments that plaintiffs are advancing involve grafting atextual limitations onto the text of 6103H4 that do not appear either in the text or the history or the structure of that provision. The first argument that they make is that there should be a substantive nexus requirement read into section 6103H4, H4A specifically. The court doesn't even have to reach that because this is not an argument that was presented to the district court, but if it does, the plain text does not include anything about a substantive nexus or other similar requirements. When Congress wanted to impose a relevance or similar requirement, it did so specifically in the adjoining provisions. H4B, H4C talk about a directly related to resolution of the issue in the proceeding standard.
Does the government recognize any limit on this? I mean, it's sure the case pertains to tax administration, no question, and you probably win on that basis, but it does seem a little freakish to imagine that the government has a rifle shot arrow dispute about some very specific tax issue and uses that as the predicate to blast out to the world the tax return of Microsoft or Bill Gates or whoever.
Sure, Your Honor. So I want to talk about what we think the statute says and why Congress wrote it in the broad strokes that it did. And I want to talk about the fact that 6103 is not the only thing that would prevent the kind of conduct that you're concerned about. So when Congress wrote 6103 H4, it's talking about adversarial proceedings where the taxpayer is present and is represented, and there's a concrete dispute between the taxpayer and the government. It is put up or shut up time where the government has to put its cards on the table. The Congress did not want to hamstring the government's ability and frustrate the government's ability to put its case forward, where it had to sit there and say in advance with crystal clarity, either get your relevance calls right, get your directly related calls right, or you're going to be subject to a separate lawsuit for damages. I can think of an instance in which one of my colleagues in a trial setting was called upon. It was a trust fund recovery penalty where she was trying to establish that certain corporate officers were personally liable for a corporation's unpaid employment taxes. And she had the corporation's tax returns, and she was using those to prove the signature authority of the corporate officers and the fact that they were showing balances out, going to the issues of responsibility and willfulness. She wasn't focused on the calculation of that liability, just showing that there was one and that someone had the authority to sign. The district court judge overseeing that case said, okay, and now counsel, I'd like you to explain where these numbers come from. How did you calculate the employment taxes that you're now trying to impose on these individuals? And she said, Your Honor, that's not an issue in the case. It's only about willfulness and responsibility. No one is contesting these numbers. And the judge said, if you're asking for a money judgment in my court, I want you to prove up every penny. Please tell me about the calculations, at which point she said, okay, I'm now going to talk about these other parts of the return that I didn't anticipate today. And trying to force a situation where you have civil liability if you make the wrong judgment call would put the government in a difficult position where it's saying, on one hand, we want to make sure we can prove our case. On the other hand, if we go too far and make a bad relevance call, we're going to be facing a separate suit for damages. And it would really result in a kind of a cottage industry where every time there's a tax controversy matter, the follow-on litigation is going to be, let's review that, all the summary judgment exhibits. Let's review all the trial transcripts. Let's see if we can go line by line and find something that wasn't directly related to the decision that was actually handed down. And then let's bring an unauthorized disclosure suit as a follow-on to that litigation. That doesn't mean that there's no recourse if the government were to do something really offensive and just say, hey, this case is about this discrete set of tax issues. We're going to put in anything we can, any return we can find on this taxpayer, maybe something that's embarrassing, something else that's in his files that has no relevance. The Supreme Court in Nixon versus Warner Communications said that a court always has inherent authority to ensure that its records are not used as a vehicle for an improper purpose. That's similar to what this court said in Hubbard. And a taxpayer who believes that the government has done something for an improper purpose or is offering information that's irrelevant or goes too far has the option of seeking a protective order to seal or strike that material. And this is not an academic point. This is in fact how Mr. Silver got relief in the Silver One case. He asked for a protective order, he briefed the Hubbard factors, and those documents that the government filed were then subsequently redacted to remove some of the information that he was concerned about. That is the remedy. It's not a 6103 remedy because that's not what Congress has stated in 6103 H4. We'd have to rewrite the statute to get where other counsel wants to get. But there is a recourse in that situation. And if we also to assume some kind of a bad faith scenario, which is very different than what we have here, where the documents that the government submitted were the very documents that Mr. Silver and Silver Limited made allegations about, made arguments about, put at issue in the first filing in the case. In both of their complaints, they put these documents at issue. But if we were to assume some kind of a bad faith scenario, we would be in in a posture where there could also be sanctions either against the government or the government council. So this is not a blank check for the government to do anything that it wants. It's just saying that Congress has limited what would be actionable under 7431 and 6103.
Right.
Thank you, Your Honor.
How much time does Mr. Zell have?
2 minutes.
Let me make it very clear what we are suggesting here. Judge Katsas, I think you began to put your finger on it. The government is saying that any case that falls within the ambit of the taxpayer party rule gives it and you heard counsel basically concede this point, gives them a carte blanche to do whatever they wish to do in the case with respect to the private information of the taxpayer. That issue has never been addressed by any court, to my knowledge. And what we're saying is that the IRS is under a duty of care. It has to take.
Said that 6103 wouldn't bar a broader disclosure, though other doctrines might.
Well,
Where do you get this limit from 6103?
Well, because all of this universe of other issues, other restraints on the IRS is built in necessarily to the statute. Let me give you an example. Sorry that I'm referring back to 4639 again, but 4639 mentions that the disclosure in a proceeding. Here they have this definition. What is a disclosure in a proceeding, which doesn't appear in the statute, which the IRS includes in 4639, says it includes disclosures and settlement negotiations. Now think about that for a second. Now the IRS is saying that if you make a disclosure in a confidential settlement negotiation, which we all know is not admissible in court under the federal rules of evidence and under the common law for years standing, that somehow falls within the ambit of 6103 as a disclosure in a judicial proceeding. And I say to you that there is this realm of under 6103 H4A1 that says that the IRS is bound by these restrictions. They simply cannot go off and disclose this kind of these kinds of documents. They must take care to do so. That's common sense. And otherwise, they did what exactly they did in this case. I mean, they in contrast to what counsel was saying, they did not. We did not raise Hubbard in our Silver One request for a motion to seal. We said that this information was confidential, was not authorized under 6103, and therefore could not be disclosed. And the IRS nevertheless did it. You know, when they provided.
You're over your time.
I'm sorry. Okay. Thank you, Your Honor. If I may just make one concluding remark with your permission. No disputes the importance, no one disputes the importance of protecting the confidentiality of tax returns and return information. No one disputes the profound implications to privacy brought upon by technology, specifically the ECF system and the PACER. In this case, our first impression, we asked the court to properly construe Section 61H4A to impose upon the IRS a common sense obligation to take necessary precautions before filing confidential tax information electronically and disseminating it to the entire planet. We asked the court to reverse the judgment of the district court and remand the case for further proceedings on the merits. Thank you, Your Honor.